Hello everyone, this is Adil Farooq. You are watching Legal Lounge with Adil Farooq. I'm sorry today I was a little bit late. Today topic is very interesting topic and today I will talk about the divorce in Canada. And thank you very much for watching my last program, which wherein I discussed marriage contracts and prenuptial contracts in Ontario, and I got some questions from a few of my viewers, and I hope they are satisfied after talking to me about their question relating to the marriage contracts and the prenuptial contracts in Ontario. So before we start, as always, I give this kind of information. This session is only for information purposes, and if you have a legal issue or if you need a specific legal advice relating to your circumstances, I will suggest call to a legal profession in your area, or you can always contact us in our office at adillaw.ca, and we will be happy to help you relating to this matter. So let's talk about the divorce in Ontario, in Canada actually. As you may know that divorce is a federal issue, and there's a divorce act in Canada, and we deal with that in order to finalize a divorce for our clients. In Canada, there are only three reasons when you can claim a divorce, and first reason is that couple must have at least 1 year of separation, and if they don't have this kind of separation and they want to take other route, there are two other reasons where you can have a divorce. The second one is assault. If one of the spouses are subject to an assault by the other, the victim can go to the court and claim a divorce. In that case, the judges don't need to wait for a year, and they can issue a divorce even before the end of 1 year divorce, 1 year separation. And the third reason is only adultery. For those kind of issues, you have to prove in the court that one of the spouses committed adultery, and in that case, they don't need to wait for 1 year separation. So mostly 99% individuals go with the separation route, and the separation is very quick and straightforward if they got a divorce after 1 year separation. The divorce process usually is pretty straightforward, and sometimes it's got complicated as well. When I say straightforward, if a couple is ready to get divorced, they can go to a same lawyer, and a lawyer can file a joint divorce when and representing both of them in that case. But remember, it's not that simple. If a couple have a child who is minor, the court will not issue a divorce until the couple have a separation agreement or have some specific agreement to deal with all the rights of the child of the marriage. When I say a child of the marriage, which means any child who is a child for both of them, and the children rights. When I talk about the children rights, this is another totally different separate issue which we will cover in the upcoming sessions. So coming back to the divorce, if the couple want to get a joint divorce, yes, we can represent them and file a joint divorce. But if a couple is not willing to go for a joint divorce, and one of the spouses wants to file a divorce, yes, that couple can file a simple divorce if there is not a child involved in this matter. So we are focusing on today's conversation on the fact that there is no child of the marriage, or the children have already been reached to the age of maturity, and they are independent and they are not dependent in any way on the spouses. Even then, they can go for a simple or joint divorce. So as I mentioned, there is one important factor of a 1 year separation. So one the separation itself is a very interesting and very deep concept when we talk about the separation. But because we're talking about divorce, I will give you a small brief idea that separation doesn't mean that a couple is living physically separate. If we go with that kind of definition, you may know some couples that husband is not in Canada, they are living in other foreign country to for a job or for a business, but the family wife is living in Canada. It doesn't mean that they are separated; they are still together. But sometimes a couple is not talking to each other, but they are living in the same house, sometimes in the same room, but they are separated. It's a matter of understanding between both husband and wife that if they are separated or not. Mostly when one of the spouse decided that they cannot live together as husband and wife, they usually considered as separated. But in order to confirm the separation, or if one spouse file a simple divorce and the other spouse challenges that divorce, then in that case, if the date of separation is a dispute, then the spouse who claim the specific date of separation, that spouse has to confirm or has to prove that this is the date of separation. And there are some factors which you should know that, for example, if a wife is making food for the husband at home, or if she is doing a laundry for both of them, or if they are going out in the parties or to see their relatives together as a couple, it means they are not separated. They have to prove that they are living separate apart of each other in order to fix a date of separation. So once they approve the separation, one of the parties can file a simple divorce in the court, and usually it it takes then it we have to serve to the other spouse that application, and that the receiving spouse have 30 days to file their claim if they have any issue or if they don't want to give the divorce. But if they don't file any issue, if they don't file any answer, or if they don't dispute the divorce application, we move forward to the second step in the divorce process, and that is called to file the affidavit of divorce. And once we file the affidavit of divorce, the file goes to the judge's chamber, and the judge will review that file. At that stage, if the judge has any concern, they contact us to provide them some further documents or some further information in order to process the divorce application. But if the judges are satisfied with everything in the affidavit, they allow the divorce, and in that case, the parties get the divorce order on the day the judge will sign the divorce order. But remember, if you guys got a divorce, you are not allowed to get married until the court will issue a divorce certificate. And in order to get the divorce certificate, you have to wait for 30 days. After 30 days, you are entitled for the divorce certificate. And once the divorce certificate issued, then the divorce confirmed. And at that, because it also passes the 30 days of appeal period, so no spouse can appeal after that date, and the divorce is confirmed after issuing a divorce certificate. And once the divorce certificate will be issued, you are allowed to get married if you want, and move on with your life. So this was a very straightforward and simple process, but this is not as simple as I mentioned. There are always some complications, and that's why you always need a lawyer or to give you a legal advice according to your own circumstances. So I'm looking at my page, and I saw I have a couple of questions from my viewers. Let me have a quick look at what they're saying. Mm, One second. Okay. Okay, so I have a very interesting question, even though that question does not relate to this part, but okay, I will touch with that. One of my viewers asked me that how to validate a foreign divorce in Ontario, Canada. Yes, it's an interesting question because I know many of our clients they travel to their back home and then they file a divorce over there. They file a divorce over there because sometimes it's more convenient for them and more straightforward and less expensive. So they decided to go there and file their divorce over there. In that circumstances, yes, you have the option to validate that divorce in Ontario, Canada, but in order to do that, you have to go to a lawyer in Ontario who's doing a who has a practice in family law, and that lawyer should give you an opinion letter, and that opinion letter will validate your divorce in Canada. And of course, that lawyer will guide you through the process of getting that opinion letter. And we also issue the opinion letter if a client approach our office. We always help them to validate their foreign divorces in Canada. And the second question I have is saying, one of my viewers asked saying, does a spouse get some preference if he or she start the divorce process? Yeah, that's a very common question. And no, the answer is no. Because whoever file a divorce, that person has no preference on the other spouse in terms of the process. But whoever start the process, of course, that person has to bear the cost of his or her lawyer. And if the second spouse is not making any objection or not filing an answer, the spouse who filed the divorce, that spouse will be able to finalize the divorce, and that spouse has to bear all the legal expenses of his or her lawyer to finalize the divorce. But in terms of legality, no, there is no preference ever given to the spouse who started the process of divorce. If this is if the other party contested that divorce application. So I think that's all for now. I don't have any other questions for my viewers, but if you guys have any questions, you are always welcome to ask those questions. You can contact us by reaching us by email. My email address is adil at adillaw.ca, and my office phone number is 905-520-7474, and my email address, I already told you email address actually, and you can always go to my website, which is www.adillaw.ca, and you will have all of our contact information over there. Thank you very much, everyone, for watching Legal Lounge with Adil Farooq. And I will come with a new interesting topic next week, same time, same Tuesday at 1 p.m. And I hope I will see you again over here. Until that time, take care of yourself and bye for now.